Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTube users getting folks the answers they need from an employment attorney. We have a question here from YouTube user Jeff Rocco 2956, who asks us, in response to our video entitled "The Senate Votes to End Forced Arbitration for Workplace Sexual Harassment and Sexual Assault Claims," Jeff, in response to that, asks, what if a case includes a list of separate charges including sexual harassment, FMLA, Family Medical Leave Act interference, failure to engage in accommodation talks, retaliation, etc., and so on? Would the other charges go to arbitration separately or go to court with a sexual harassment charge? I recently started seeking representation for a situation like this. Thank you, Vince. Your videos gave me the courage to seek representation. Jeff, I'm really sorry that you have to seek representation at all. It means something bad happened to you, and that sucks. I sincerely hope you get paid and get made whole. Now, generally speaking, cases will be brought together, all the claims. It is normal for there to be many claims in an employment law case. Sexual harassment, FMLA, failure to engage in the accommodation dialogue, failure to accommodate, retaliation claims. Generally, these would all go together. Now, it is possible if you are dealing with a statute that precludes mandatory arbitration for one specific set of claims, it is possible that for tactical reasons, your attorneys would file that one specific claim that has been exempted out of mandatory arbitration. They would file it in potentially federal or state court outside the arbitration, and then in parallel run the arbitration for the other claims at the same time. That is certainly possible. Very inefficient. It's something we would do if we, like here you're saying, I think the sexual harassment claim could be run outside the mandatory arbitration. Right. We would do that if we thought the sexual harassment claim was really valuable and was likely to do much better outside the arbitration with a jury in like federal or state court. Now, if that's not the case, if it's just like the exempted out claim would not be the star of the show or the most valuable claim or something with like a real serious value, like these claims are all potentially valuable, but like different claims have different valuations based on different fact patterns. It's not all claims are created equal. So if it's just like a weaker one of your claims, I think a lot of firms would probably say, hey, just put it in the arbitration because the stars of the show are in the arbitration anyways. This is a sideshow. It's not the most valuable claim. And, we can't necessarily afford to run like two full litigations, one in arbitration, one in federal court or state court. Just because you got this other sideshow claim, it's not worth as much. They might not be like super excited to split the two out, right? That being said, again, for tactical reasons, if it is the star of the show or if it's a really valuable claim and you think it will do better in federal or state court, that is where you would file it because the goal should be to maximize your client's take on the case and get them as much as you possibly can, because in so doing, and so helping your client and maxing their recovery, generally speaking, a contingency employment attorney would make the most money, right? If you help the person the most you can possibly help them, you then also help yourself the most you can possibly help yourself. And we love money almost as much as we love helping people. In fact, making money helping people is one of the primary reasons to become an employment attorney. Possibly the only one that I can think of. Now, certainly not the quality of life. I'll tell you that right now. So, Jeff, it is possible they'd be split out. But I think it's going to depend on how the firm you're working with looks at it from a tactical perspective, and also the fiscal realities and the efficiencies of the situation. That will be a consideration for most firms, I think. Jeff, I hope this helps. I wish you great success with your claims. I'm sorry you need an employment attorney. That's never a good thing, but I will be rooting for you and cheering for you. Is that the same thing? What is rooting? What is it to root for someone? That is to cheer for them, right? I don't know. Seems redundant. Anyways, like, subscribe, comment down below. Share our channel so it may grow. Take care, everybody.